Good morning. Thanks for coming. Last month, during the State of the State message, I made a promise to a mother from Newark that we would help to reduce the cycle of violence so prevalent in many of our urban communities. Today, I'm proud to stand here with the Attorney General, with a number of county prosecutors from across the state to propose changes in our bail process with a constitutional amendment that modifies the right to bail in New Jersey, one that works to enhance overall public safety while securing the integrity of our criminal justice system. The change, which parallels the federal system, aims to provide our courts with the ability to keep dangerous offenders in jail and off community streets rather than giving them an opportunity to commit further acts of violence, intimidate witnesses until the time of their trial. A 2007 study by the Bureau of Justice Statistics found that of pretrial releases, about a third of released defendants were charged with one or more types of pretrial misconduct. Nearly a quarter had a bench warrant issued for failing to appear in court, and about a sixth were arrested for a new offense. More than half of those new arrests were for felonies. Making changes to our bail laws is a common sense move to stop preventable crimes from occurring by allowing a judge to use his or her common sense approach to deciding whether someone deserves to be released or not. Their history of crime and the potential danger to individuals, both witnesses and innocent citizens on the streets, should be one of those factors that a judge should be able to consider. This revision establishes an exception authorizing pretrial detention when a court finds that no amount of bail, pretrial release conditions, or combination of bail and conditions would assure the defendant's appearance, protect the safety of any person and of the community, or maintain the integrity of the criminal justice process. This long overdue common sense measure can only improve the quality of life in our communities by keeping the most violent criminals off the streets and ease the minds of folks around the state against those who have been charged with violent crimes. And so the group of folks I have up here are prosecutors that I've worked with over the course of my career, both as a U.S. attorney and now since I've been governor. They're experienced prosecutors on both the state and federal level, and people who I count on, along with the Attorney General, for advice and counsel on these type of issues, and ask them to be with me here today to show that what we're attempting to do here is something that's going to be good for our state and good for the law enforcement community. So I'm going to introduce the Attorney General for some remarks, and then we'll come back to take questions. General?
Governor. Thank you. Good morning, and thank you, Governor. Thanks to the prosecutors who joined us here today. The Governor's got this right. This is a common sense solution to what many people may think is already going on, because it does happen in the federal courts. If you're the victim of a crime, you shouldn't have to worry about whether or not a person's given bail without consideration to whether or not they pose a danger to you or to your community. Witnesses in these cases shouldn't have to worry about it either. If a person's bailed, the people that are affected by it, the victim, the victim's family, their communities, the places where these crimes occur, should have the peace of mind to know that the judge has considered whether or not they pose a danger to that community. We thank the Governor for making this proposal. Everybody here, from a law enforcement perspective, applauds it because it makes a lot of sense and gives us another tool that we need to do our jobs. Thank you.